The Supreme Court chamber grew still as Justice Amy Coney Barrett leaned forward, a faintly mocking smile tugging at her lips. As the newest justice on the nation's highest bench adjusted her black robe, she fixed her gaze on former Florida Attorney General Pam Bondi, who stood poised and composed at the podium. Moments earlier, Barrett had cut into Bondi's argument with a pointed question, her tone unmistakably laced with skepticism. "Ms. Bondi," Barrett's voice echoed across the marble hall, "you claim that the constitutional structure supports your position. Yet I'm having difficulty finding any legal precedent that aligns with your interpretation. Perhaps I've overlooked something during my years on the bench," Barrett added, her words edged with irony. A few of the justices exchanged knowing glances as quiet laughter stirred among those seated in the gallery. The ridicule, though subtle, was unmistakable. Here was a Supreme Court justice appearing to publicly undercut a veteran attorney in the very heart of American jurisprudence. Barrett's faint smile hinted that she believed she had uncovered a fatal flaw in Bondi's argument. At the podium, Bondi tightened her grip, her knuckles turning pale. Just 30 seconds remained. Half a minute to recover from a pointed rebuke delivered from the highest bench in the country. What unfolded next stunned the Supreme Court and would go on to become one of the most extraordinary moments in modern legal memory, leaving Justice Amy Coney Barrett visibly unsettled and sparking intense discussion throughout the legal world. Before we delve into Pam Bondi's powerful response that silenced the courtroom and dramatically shifted the dynamic, it's important to understand the gravity of the moment. Justice Amy Coney Barrett's rapid ascent to the nation's highest court had already made her a formidable presence in American law. Appointed in 2020 after a highly charged confirmation process, she quickly distinguished herself as an intellectual heavyweight. Known for her incisive questioning and steadfast originalist interpretation of the Constitution, Barrett had garnered respect across the ideological spectrum, even among those who fundamentally disagreed with her legal views. At 51, Justice Barrett embodied a new wave of conservative judicial philosophy. A former law professor at Notre Dame with impeccable academic credentials, she became a prominent figure among conservatives, not only for her legal acumen but also for her personal life, including her devout Catholic faith and role as a mother of 7. While hailed as a cultural icon by the right, Barrett was met with skepticism from progressives, especially on issues involving religious liberty and the scope of executive authority. Inside the courtroom, Barrett earned a reputation for occasionally using a calm yet incisive form of mockery when confronting arguments she believed lacked constitutional grounding. As the court's most junior member, she typically waited until later in proceedings to speak, making her questions all the more striking when they came. Pam Bondi stood before the Supreme Court that morning backed by a formidable legal pedigree. As Florida's first female attorney general, she had tackled high-profile prosecutions and defended the state's laws in appellate courts. Following her time in public office, she transitioned into a successful private legal career, focusing on constitutional litigation. By the time of this argument, she had already appeared before the Supreme Court 3 times, prevailing in 2 of those cases. At 58, Bondi's composed presence, her sleek blonde hair and polished demeanor masked a fiercely analytical mind and a seasoned prosecutor's instinct for striking at the heart of an opponent's argument. Those familiar with her work knew she was most lethal when underestimated, something Justice Barrett was about to experience firsthand. The case at hand, Meridian Industries versus Department of Labor, dealt with weighty questions surrounding the limits of federal regulatory authority. Representing Meridian, Bondi challenged what she described as unconstitutional overreach by a government agency. But this was more than a dispute over one corporation's rights. The outcome had the potential to redefine the balance of power between federal agencies and private enterprise across the country. All 9 justices understood the gravity of the moment. A ruling in favor of Bondi's client could dramatically restrict bureaucratic authority that had gone largely unchecked for generations. A ruling against Meridian would solidify the dominance of federal agencies in a manner that deeply unsettled conservatives wary of an ever-expanding regulatory state. The courtroom was filled to capacity. Journalists, legal scholars, law students, and officials from federal regulatory bodies had gathered, aware of the case's far-reaching implications. SEU's blog had dubbed it the most consequential administrative law case in a generation, and constitutional experts had been locked in debate for months over what its outcome might mean. As Bondi opened her oral argument, the justices engaged with routine yet probing questions. Justice Sotomayor challenged her on the potential impact to worker protections, while Justice Alito appeared more receptive to her critique of unchecked agency authority. When Chief Justice Roberts inquired about possible remedies, Bondi offered a thorough, well-reasoned answer that seemed to satisfy him. Then came Justice Barrett's pointed interruption, not a deep dive into legal doctrine, but a seemingly dismissive jab at the lack of precedent supporting Bondi's position, delivered with a faint, knowing smile. The message was unmistakable to everyone in the chamber. Barrett believed she had cornered Bondi, exposing a critical flaw in her case, and perhaps even enjoying the moment. What Barrett didn't know was that Bondi had spent the past 3 months preparing precisely for this line of attack. She had anticipated this challenge, studied every angle, and was ready. As she took a calm breath and stepped into her rebuttal, the balance of power in the courtroom was about to shift in an unexpected and unforgettable way. "Justice Barrett," Bondi began, her tone composed and respectful, unfazed by the pointed challenge. "I appreciate your question regarding precedent." She paused deliberately, locking eyes with Barrett before continuing. "In fact, I'd like to draw the court's attention to 3 decisions that form the backbone of our argument." Without glancing at a single note, Bondi confidently cited Whitman v. American Trucking Association's 2001, accurately referencing Justice Scalia's majority opinion, which imposed clear limits on agency discretion. She then transitioned smoothly to FDA v. Brown and Williamson Tobacco Corporation 2000, reciting key language that emphasized how significant regulatory authority must rest on explicit congressional authorization. The courtroom's energy shifted. Several justices leaned forward, their interest clearly piqued. As Bondi spoke with precision and control, Barrett's smile began to fade, the confidence in her earlier challenge quietly slipping away. "But perhaps most relevant to your question, Justice Barrett," Bondi continued, her voice now more assertive, "is your own opinion in Collins v. Yellen, 2021. She paused for effect. "You wrote, and I quote, 'When interpreting a statute, courts must be careful not to extend federal agency power beyond the boundaries clearly set by Congress.'" A ripple of surprise moved through the courtroom. Bondi had just turned Barrett's own words against her, words that strikingly aligned with the argument she was now advancing. Pens scratched hurriedly across notepads as reporters took down the moment, while law clerks exchanged subtle, wide-eyed glances. Barrett's expression stiffened, the change barely visible but unmistakable. "Ms. Bondi, Collins addressed a different regulatory context entirely," she began. "With respect, Justice Barrett," Bondi interjected, her tone formal yet firm, "the principle you articulated in Collins applies with equal force here. If I may elaborate, it was a bold move. Rarely do attorneys interrupt a Supreme Court justice." The tension in the chamber spiked as Barrett, caught slightly off guard by the confident rebuttal, gave a small but unmistakable nod, granting Bondi permission to proceed. Bondi seized the moment. Without hesitation, she launched into a thorough examination of 5 additional Supreme Court decisions, methodically linking each one to the core of her client's position. Her delivery was poised and unflinching, her gaze steady on Justice Barrett, whose earlier air of condescension had given way to a look of sharpened attention. "Moreover," Bondi continued, "this court's ruling last term in West Virginia v. EPA, which Justice Barrett joined, strongly reaffirmed the major questions doctrine. And it is that very doctrine we rely upon today." Justice Elena Kagan leaned forward, intrigued. "Ms. Bondi, West Virginia dealt specifically with environmental regulation. Are you suggesting that its legal reasoning extends to labor policy as well?" The question opened a door for Bondi to further broaden her argument. Over the next 3 minutes, she engaged in a rigorous exchange with Justices Kagan and Gorsuch, deftly navigating the nuances of administrative law while repeatedly circling back to precedents Barrett had claimed were absent. Her answers were not only well-informed, they were strategically precise. The tone in the chamber had undeniably shifted. What had begun as a dismissive interjection from Barrett had evolved into a striking display of Bondi's legal expertise. Barrett's earlier smirk now felt misplaced, perhaps even inappropriate, in light of Bondi's commanding performance. Following Bondi's comprehensive and strategically sharp response, the tension in the courtroom escalated yet again. Justice Barrett, seemingly intent on regaining control of the exchange, returned to her original line of questioning. "Ms. Bondi," she said, her voice still composed but now tinged with a subtle defensiveness. "While the cases you cited are undoubtedly relevant, none speaks directly to the precise agency action at issue here. The Department of Labor's authority under this statute is shaped by a different legal framework. It was a professional response, but the shift in tone was unmistakable. The justice who had earlier dismissed Bondi's argument with a smile now seemed to be reaching, seeking a way to differentiate the precedents Bondi had so skillfully presented. Barrett, once on offense, was now on her heels. Bondi nodded with practiced respect, but those familiar with her courtroom style recognized the look in her eyes, a focused intensity she often displayed during closing arguments in high-stakes trials. She was about to strike with her strongest point, one she had prepared meticulously, knowing it aligned with a notable vulnerability in Barrett's own judicial philosophy. "Justice Barrett," she began, her voice measured and deliberate, "you've raised an important point about statutory context. And that is precisely where our argument finds its greatest strength." Bondi gave a slight nod. "With the court's permission," she said calmly, "I'd like to respond directly by referring to the textualist principles that you, Justice Barrett, have consistently championed throughout your judicial career." It was a strategic move, and the setup was clear. Barrett had built her legal identity on the foundation of strict textualism, the belief that the precise wording of statutes should govern interpretation, not legislative intent or overarching policy goals. Now, Bondi was preparing to turn that philosophy against her. "Justice Barrett," she continued, her tone unwavering, "in your 2018 article in the Columbia Law Review, titled Statutory Interpretation and the Primacy of Text, you wrote, and I quote, 'When a statute's text is clear, agencies may not reinterpret that language to expand their authority, regardless of policy considerations.'" She paused deliberately, letting the quote hang in the air. The weight of Barrett's own published words, now wielded in real time against her position, reverberated through the chamber. Barrett's own words now lingered in the silent courtroom, thick with implication. "The statute before the court today," Bondi continued, her voice steady, "contains language nearly identical to the one you analyzed in that article." She didn't miss a beat. Specifically, on page 147, you criticized the D.C. Circuit for permitting an agency to broaden its authority under a similarly phrased statute. A hush fell across the chamber. This was no longer just a matter of case law. Bondi was dissecting Barrett's own scholarly work, turning the justice's academic writings into a sharp tool of rebuttal. Several justices shifted in their seats, the weight of the moment not lost on them. The rhetorical trap had sprung, and it was airtight. "In fact," Bondi added, pulling a document from her folder with precision, "I've brought a comparison for the court's consideration." She held up the paper. "This is the text of the statute you analyzed, side by side with the Department of Labor provision we're addressing today. The structural and linguistic parallels are unmistakable." She handed the material to the courtroom clerk, who moved swiftly to distribute copies to the justices. As Justice Barrett received her copy, a flicker of recognition crossed her face, her eyes briefly widening in a moment the cameras didn't miss. It was the realization that her own academic writing directly conflicted with the position she had just taken from the bench. Sensing the shift, Bondi pressed her advantage. "In addition," she said smoothly, "in your Madison lecture at NYU Law School just last year, you emphasized that consistency in judicial philosophy is the foundation of credible constitutional interpretation." She paused just long enough for the words to sink in. "That very principle of consistency," Bondi continued, "is what we are asking this court to uphold today." The reference was surgical. Barrett's lecture, delivered to wide acclaim only months earlier, had been a resounding affirmation of interpretive integrity, regardless of a case's political or policy consequences. Now, in real time, Bondi had turned that principle into a challenge. Barrett faced a stark choice: adhere to the standards she had so publicly championed and rule in Bondi's favor, or undermine her own judicial philosophy. Justice Sotomayor, perhaps sensing Barrett's growing discomfort, attempted to shift the conversation. "Ms. Bondi," returning to the statutory question, "if I may, Justice Sotomayor," Bondi interjected politely, but with unmistakable firmness. "One final point." She paused, then delivered her closing strike. The textualist framework that Justice Barrett has so eloquently championed, through her scholarship, her rulings on the Seventh Circuit, and her opinions on this very court, can lead to only one conclusion in this case: that the Department of Labor acted beyond its statutory authority. Bondi turned her focus back to Barrett. The earlier expression of quiet amusement on the justice's face had vanished, replaced by one of solemn introspection. "The precedents do exist, Justice Barrett," Bondi continued. "They live in the rulings of this court, in your own written opinions, and in the constitutional principles you've consistently defended. And when those principles are faithfully applied to the clear language of the statute before us, they demand a ruling in favor of my client." The courtroom fell still. A heavy silence settled over the chamber as the weight of Bondi's argument and its implications lingered. The dismissive smile that had opened the exchange was now a distant memory, eclipsed by the unmistakable realization Justice Barrett's own judicial legacy had been used to unravel her position. What had started as a routine oral argument had evolved into a remarkable moment of intellectual confrontation, one that would be remembered as a defining exchange in the annals of Supreme Court advocacy. "Thank you, Ms. Bondi," Chief Justice Roberts finally said, breaking the charged silence. "Your time has expired." Bondi gathered her notes with calm composure and stepped away from the podium. At the bench, Justice Barrett scribbled rapidly in her notepad, the self-assurance she had displayed earlier now replaced by visible intensity. The justice who had once laughed appeared visibly shaken, grappling with the profound way her own legal philosophy had been invoked to challenge her stance. As the government's attorney stepped forward to begin his rebuttal, it was clear that the tone in the courtroom had shifted. The justices, the attorneys, the press, and the gallery had all witnessed something extraordinary, a seasoned advocate turning the tide of a Supreme Court argument, not with theatrics, but with precision, restraint, and the power of the court's own intellectual foundations. A Supreme Court justice had laughed off an argument, only to watch her own judicial philosophy and published writings become the foundation of one of the most compelling oral arguments in recent memory. The Bondi-Barrett exchange echoed far beyond the stately walls of the Supreme Court. As those in attendance filed out of the chamber, reporters scrambled to file their stories. Headlines quickly emerged with variations like "Barrett confronted by her own words," and "Bondi flips the script, uses Barrett's writings against her." Legal commentary was swift and sharp. Within hours, blogs and legal news outlets were dissecting the exchange. Above the Law published an in-depth piece titled, "When Laughter Backfires, Barrett's Dismissive Moment Becomes Bondi's Triumph." SCOTUS blog's evening recap was equally striking, calling the argument a rare moment where a justice was publicly confronted with her own inconsistency and visibly affected by the realization. Clips of the dramatic exchange, especially the moment when Justice Barrett's expression shifted upon receiving the side-by-side statutory comparison, quickly went viral across social media. The hashtag Bondi vs. Barrett began trending nationwide as legal analysts and commentators from all ideological backgrounds joined the conversation. Conservative legal scholar Jonathan Adler weighed in, tweeting, "Regardless of how you feel about the case, Bondi's preparation was outstanding." Leveraging Barrett's own textualist framework to advance her argument was a brilliant tactical move. From the other side of the spectrum, liberal constitutional law professor Lawrence Tribe remarked, "Today, we witnessed something extraordinary. A justice's own judicial philosophy being skillfully employed to expose a potential inconsistency." This was oral advocacy at its finest, a demonstration of how legal argument can challenge even the most established voices on the bench. For Justice Barrett, the fallout was swift and complex. According to sources inside the court, she canceled her scheduled afternoon meetings and remained in her chambers long after her colleagues had left for the day. When the court reconvened the following morning, Barrett was noticeably more restrained. Her usual sharp questioning had softened, and the dismissive edge that had defined her earlier exchange with Bondi was conspicuously absent. The media response quickly extended beyond the legal press into mainstream coverage. The Washington Post ran a front-page analysis scrutinizing Barrett's judicial record for similar contradictions, while the New York Times published a widely read op-ed titled, "When Judicial Philosophy Meets Real-World Application: Lessons from the Barrett-Bondi Moment." Initially, conservative media attempted to minimize the significance of the exchange. But as clips of the confrontation continued to circulate online, even traditionally supportive outlets were forced to acknowledge the uncomfortable reality. Justice Barrett had been placed in a difficult and deeply public position, one shaped not by political opposition, but by the very principles she had long championed. Fox News legal analyst Andrew McCarthy remarked, "Justice Barrett is undoubtedly one of the most brilliant legal minds on the court, but today, Pam Bondi highlighted a potential inconsistency that may prove difficult to reconcile in the final opinion." For Pam Bondi, the aftermath brought a surge of professional recognition. Her performance was praised across the legal community, with law schools requesting transcripts and notes from her argument to use in appellate advocacy courses. Within days, 3 prominent law firms reportedly reached out with partnership offers. When asked about the exchange during a brief interview after a later court appearance, Bondi remained measured and focused. "This was never about Justice Barrett or me," she told reporters. "It was about ensuring the Constitution is applied with consistency and integrity. The court deserves profound respect," Bondi said, "but it's the duty of every advocate to highlight when the judicial application of principles appears inconsistent." Her calm, principled response only strengthened her reputation, not as someone seeking the spotlight, but as a serious and disciplined constitutional lawyer. Privately, the impact of the exchange extended well beyond the public eye. According to sources familiar with the court's internal deliberations, the confrontation weighed heavily during the justices' closed-door conference, where preliminary votes are cast following oral arguments. In that meeting, Justice Barrett reportedly spoke at length about reevaluating her initial stance, a rare and telling moment in the court's internal dynamics. The advocate raised arguments that demand serious consideration, Justice Barrett reportedly told her colleagues, a rare admission that an oral argument had significantly shaped her perspective. Sources close to the court revealed that 3 justices, who had initially leaned toward the government's position, began to reevaluate their stance after Bondi's compelling presentation of textualist reasoning. 3 months later, when the court issued its opinion, the influence of that pivotal exchange was undeniable. In a 6-3 decision, the court ruled in favor of Bondi's client. Justice Barrett authored a concurring opinion, explicitly addressing the textualist principles highlighted during the oral argument. "Consistency in the application of interpretive methods," she wrote, "is fundamental to preserving the integrity of the rule of law." Barrett wrote, "When the text of a statute is unambiguous, as it is in this case, agencies may not extend their authority beyond what Congress has expressly authorized, no matter how compelling the policy rationale." The language closely mirrored the very quote Bondi had recited from Barrett's own academic work, creating a powerful full-circle moment. Legal scholars quickly took note. Barrett's concurring opinion read not only as a judicial statement, but also as a subtle personal acknowledgement. Though she never directly referenced the earlier courtroom exchange, the opinion effectively conceded that her initial skepticism toward Bondi's argument had been misplaced. In validating the core of Bondi's position through her written concurrence, Barrett lent the advocate's argument lasting credibility. The impact went far beyond the case at hand. Law schools began incorporating the Bondi-Barrett exchange into appellate advocacy curricula, using it as a textbook example of how to challenge a skeptical judge with precision, professionalism, and respect, turning a moment of confrontation into one of constitutional clarity. Constitutional law courses across the country began teaching the case as a definitive example of textualist reasoning in action and its implications for the modern regulatory state. The court's decision marked a major limitation on agency power, making it clear that federal departments must now secure more explicit congressional authorization before enacting significant policy shifts. Business groups hailed the ruling as a vital check on administrative overreach. In contrast, progressive organizations voiced concern over its potential to undermine regulatory protections, particularly in areas like labor and the environment. 6 months after the landmark ruling, when Pam Bondi returned to argue another case before the Supreme Court, seasoned observers noted a distinct change in Barrett's demeanor. The earlier tone of skepticism had vanished. This time, Barrett engaged with Bondi's arguments with care and courtesy, posing thoughtful, substantive questions without the sharpness that had defined their previous exchange. A junior clerk was even reported to have overheard Barrett remark to a colleague before the second hearing, hinting at a newfound professional respect for Bondi's advocacy. "I learned an important lesson about assumptions the last time Ms. Bondi appeared before us." It was perhaps the most revealing acknowledgement of just how completely Bondi had turned a moment of judicial skepticism into a landmark victory for constitutional advocacy. What began as a fleeting instance of courtroom condescension grew into something far more enduring, a case study in how preparation, intellectual discipline, and strategic clarity can transcend even the most lopsided power dynamics. The Bondi-Barrett exchange became more than a dramatic moment at the nation's highest court. It became a pivotal lesson in the enduring power of the law. That a Supreme Court justice once laughed dismissively at an argument, only to later affirm its core principles in a published opinion, underscores a powerful truth. In America's legal system, even the most authoritative voices are not immune to challenge when met with reasoned, principled advocacy. This remarkable episode reminds us that the rule of law is not upheld by power or position, but by clarity of thought, rigorous argumentation, and the courage to speak truth in the face of authority. When Pam Bondi entered the Supreme Court that day, she brought with her more than just a case file. She carried a deep, strategic understanding of Justice Barrett's own judicial philosophy. That insight would prove more powerful than the fleeting advantage of a dismissive remark or a knowing smile from the bench. In the end, it wasn't authority or status that won the day. It was preparation, principle, and the ability to engage the court on its own terms. The Bondi-Barrett exchange stands as a lasting reminder. In America's courtrooms, as in life, true influence is not derived from position alone, but from the power of reasoned argument, intellectual discipline, and the courage to confront even the highest authority when justice demands it.